Good morning, ladies and gentlemen. If you are on the committee, please take your seat. We're going to begin as soon as possible. Um, Good morning. You can, yeah. Um, if we can all stand and do the Pledge of Allegiance, please. And Representative Petrino, can you lead us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Representative Love, could you run next door and ask Representative Markel to come in and introduce his bill, and then he can go back to testify over there for me, please, and thank you very much. It is a little bit after 10, and I do see that there are people here who are very interested in testifying on our bills. I'm asking the prime sponsor of House Bill 1185 to come in and open his bill, and we will proceed from there. He is in another committee. So if you will bear with me for another minute, that would be fabulous, and I appreciate it.
Good morning, committee. We will call our session in order and ask the chair to approach the bench to introduce House Bill 1185, FN.
Thank you, Mr. Interim Chair. I am introducing this bill for Representative Markel. So I'm just going to open the bill, then I'll go back to my seat, and we will hear testimony on it. And I'm sure that Representative Markel will be able to give you more information and handouts on the bill. This is House Bill 1185, relative to the offense of endangering the welfare of a child. This bill is extremely important bill, and I know that it's very important to Representative Markel, although he is testifying in another committee at the moment. So if the committee would indulge me, I will ask the chair to recess this bill until the end of the day or later on, so that Representative Markel can testify. If that is not how the committee wants to proceed, that's absolutely fine. He can introduce his testimony later.
Thank you very much, Madam Chair. With the committee's support, we will recess House Bill 1185, awaiting Representative Markel's arrival. And we'll ask for a vote. We don't have to do a consensus, we can do it by hand. Yeah. All those in favor? Opposed? It's unanimous.
Thank you, Mr. Chair.
Thank you.
Since we've now recessed that bill, we will have a little bit of a break. The next bill will come up at 11. And if Representative Markel is not here, then I will open that bill as well. Thank you. You have questions for me?
I have one question.
One question, Representative Raymond.
Thank you. And it is a general procedural question.
Mhm.
And that is, should Representative Markel be done in, say, 10 minutes or 15 minutes? Could we take it up at that point?
We will reconvene that bill, yes.
Okay. So other people who were wishing to testify shouldn't go far.
That's correct.
Okay.
They should not. You're right.
Thank you
Thank
so
you.
much.
A very
you.
good point, Representative Raymond.
I will now duck in and see where Representative Markel is in his testimony and see how much longer it will take. I hope it wouldn't take any more than maybe 5 minutes or so.
We will await your immediate response, Madam Chair. Okay, good morning again, members. I will call the meeting back to order and to take advantage of members to ask questions and hear the testimony of two speakers that we have pink cards on. So that being said, I'd like to recognize Ms. Leon.
Should I text her?
Oh, excuse me, the Honorable Leon.
Dave, are you texting her? Excuse me, Representative Love, are you texting her?
Okay, well, pending that, then we will recognize the next pink card we have, which is Ms. Elizabeth Sargent. I'd like to ask her to approach the bench. That's right, it's for big comments. And what we have is to facilitate hearing the specifics from you, and you have 3 minutes to present, and then gives the members of Children and Family Law the opportunity to question going forward.
Okay,
Yeah,
thank
you-
you so much, Chairman McMahon.
You have
My name is Beth Sargent. I work for Champaign Capital Group here today, representing the New Hampshire Association of Chiefs of Police. And so I'm going to go with that limited time, which is great. I'm going to hand in testimony from Sergeant Marvin from Newport Police Department in opposition to the bill respectfully. I just want to bring to the committee's attention, there's been a lot of movement in this statute. So I'm going to hand in, I have enough copies for you, a copy of RSA 639-3, where paragraph 3 just became effective January 1, 2026. And then subsequent to that, House Bill 257, the House, you just passed it in January, a retained bill relative to the crime of endangering the welfare of a child or incompetent. It also amends RSA 639-3, Roman 1. So this has passed. The House position is to support this bill, and it will now be heard in the Senate. It has not been scheduled for a public hearing. And that brings us to House Bill 1185. So if 257 passes and then 1185 comes along and gets signed, they would contradict each other. One would go away. And I will hand in copies of both RSAs, and then briefly, I'll just read a couple of comments from the detective's testimony. His testimony, I appreciate the intent of this bill. New Hampshire has work to do when it comes to strengthening protections for children who are the most vulnerable population in our state. While this bill appears to be aimed at that goal, I believe it would have unintended consequences that may ultimately undermine it. So he goes into pretty detailed information about the words in the bill. And I am not a technical expert in this area, but I'm happy to take back any questions that get asked.
Is that your testimony?
Yes, thank you.
Questions, please. Representative.
Thank you,
Yes, sir.
Mr. Chairman, and thank you, Ms. Sargent. Would it be your testimony that HB 257 needs a year to play out to see how it works before we try to change it?
Yes, and I just want to be clear, it has gone to the Senate, so it hasn't had a public hearing, but it has passed the House. Yes, and law enforcement does support House Bill 257 as amended.
Thank you.
Thank you.
Representative.
Thank you, Mr. Chair. You're aware that HB 257 had lengthy hearings
Yes.
in the House Criminal Justice,
Yes,
and the sergeant from Newport testified at those hearings.
he did.
And you're aware that I submitted, I'm sorry, I keep forgetting to ask for follow-up.
Follow up, sir.
And you're aware that I submitted a replace all amendment to HB 257, which is what passed the full House.
Yes.
And follow-up.
Continue, please.
Thank you. And HB 257 changed the mental state for child endangerment from purposely to recklessly. Is that correct?
Correct.
And the sergeant was in support of that.
He was.
I'll leave it at that.
All right, and I'll pass in all these pieces so you guys can try to make some sense of it as well.
Right, and just a question for myself, just reading the
Sure.
bill, it could be a typo, but it says on line 4, it says any person who owes a child. Would you know what the correct word would be as opposed to owes?
Hold on, since we have the statute in front of us, 639(3)(1), a person. Okay, so,
Owes the duty
okay,
of
so
care.
1185 is repealing and reenacting, which is part of the problem. So, I bet it's any person who. It could be, there's knowingly
Oh.
endangers, I'm not confident, it's not in the
And
current law, I'm not
Representative-
sure what the word is.
Representative Pearson.
I think the verb and the rest of it have been separated. Any person who
Oh.
owes a child a duty of care. Now, that makes sense.
Oh,
And what's
see.
in between is a elliptical phrase that should be somewhere else, and I write that way too, so I get it.
yeah, there was that, I was going by my comma rules. Okay. I think we have.
I see that now
I see
too,
it.
yep.
Get it? Yeah.
Yeah, it matters to actually read the bill. I'll tell you. Representative,
Do you think it might make sense to interim study this bill, see what happens to 257, and then, if need be, come back to it?
Yeah, we'd be in support of that motion.
okay, thank you. Representative Pearson.
Or, thank you, Mr. Chairman. Or might we just hold execing it to see what happens over in the Senate? That's a question for whoever wants to answer it.
Is that when to retain the bill?
Just hold on to it
Or
and don't
just-
exec
just
it and
hold.
see what the Senate does with this. And if it passes, it gets signed, it's moot.
Yeah, since it's a full contradiction as you.
It
as you
is, it's
stated.
dramatically different. I did have a note, I did have a note from Lieutenant Georgilis from Manchester that he appreciated the felony charges. I hope I get this right. However, it made it harder at the misdemeanor level. So there's a lot of contradiction in here.
Representative Raymond.
Thank you. I wonder if, I wonder about some of the language, and perhaps it's a question for Representative Markell when he comes back, because I noticed that instead of recklessly, it says negligently does this. I'm curious about the term, as you just pointed out, the person who owes a duty of care. Well, what about somebody who doesn't owe a duty of care? Right now, they could be charged with endangering, but this would limit it to only parents or caretakers. And so I'm curious if that's in the officer from Newport's testimony or not.
That is where it'd be over my head.
Okay.
I think it's almost I said to someone last night, I feel like I'm writing a college term paper because we'd have to take what's just passed, what we're hoping passes, at least, and it is the House position. And so this would be very different. So
Okay.
we'd have to work through it. And I don't know the answer.
Okay.
I'm sorry about that.
Thank you. Yeah, and my only follow-up again is a language question about in line. Hold on, I gotta look it up.
And let me just check his testimony too, because he does go into detail. His last sentence in his testimony, I believe House Bill 257 more effectively and simply addresses the shortcomings of the current statute while giving vulnerable children a stronger chance at safety, stability, and the happy childhood they deserve, which is still not answering your question.
Mhm.
It doesn't look like he addressed that specific question.
Okay,
I'm sorry about that.
that's all right. I will wait and ask.
Yeah.
And I'll
Representative
submit
Markell.
his testimony too, so you
Okay.
can go
Thank
through
you.
a little bit more detail.
Representative.
Thank you, Mr. Chairman. Did you say that you have copies for us of all
Yes,
of that?
of
Can we
all
go
of
ahead
it.
and like pass that out just
Yes,
that way?
yes.
It might, we can take a look at it. Thank you.
Do you want me to stand in witness chair?
No, you've achieved a tremendous benefit of intelligentsia, so I thank you very much.
All right, thank you so much for having me.
Okay. I'd like to recognize the Honorable Betty Gay.
It's Betty Gay of Salem, and I fully support the idea, excuse me, that in order to achieve the goals of these multiple bills, it's a good idea to wait, hold this one, so that you can work them together, because we don't know what's going to happen to the bill in the Senate. So this would be a handy one to work on if something doesn't get that one to pass. So I support this idea to hold the thought and wait to see what's the most important, most effective way to get it to pass.
And that's specifically 257.
Yeah.
And that's a house, is that a House bill?
I'm sorry, yes, HB 257.
HB, okay, because I don't have it in front of me. I don't want to misquote.
You're about to get it. It's a House bill that had a replace all amendment in criminal justice, which passed criminal justice and passed the House with a resounding vote, and is now in the Senate. If I could address a concern of Representative Raymond's.
Yes, yes, please.
In looking at current 639-3, though it reads, I understand you're reading a person is guilty, it just says a person. If you read, and it's coming to you, it says a person is guilty of endangering the welfare if he knowingly endangers the welfare of a child under the age of 18, etc., by purposely violating a duty of care. So it has that same duty of care language. It's not just a person, it's just a person who has a duty of care.
Your handouts are being collated right now.
May I comment on that?
Yes, Madam Gay.
I really appreciate what Representative Raymond said, that I don't think it should be restricted. If somebody else who's not responsible for that child induces them to do something that's not safe, I think they ought to be covered by the law too.
Okay, Representative.
My understanding is that conduct, if a person doesn't owe an individual a duty of care, like a child care person, or that conduct is covered by the reckless conduct statute already.
Okay, so this is to add to that.
Yes.
Okay, thank you.
Anything further?
No, that's
Okay.
it.
Any questions for Honorable Betty Gay? No. Okay, thank you very much.
Thanks.
Okay, let me put that right there. And has Ms. Leon entered the room? Oh, okay. Then
We will just, I will rip this up, so
Yes.
we know that it's not something I have to pass in. Okay, thank you.
okay, that's all that we have offering testimony on the bill right now. I said, so we'll recess at 10:35 and pending the next bill scheduled for.
Mr. Chairman, I think
4:11.
you have a point of order coming.
Oh, yes, Madam Chair.
Thank you, Mr. Chair. I just received a message that he will be approximately 1 minute. So if we can recess for maybe 5 minutes and then he can testify on that and maybe go right into his next bill, would that be amenable to the chair?
Oh, okay,
Thank you kindly, sir.
let's do that. I was waiting for any members to say, no, I'm not waiting for that.
You'll have to go back into recess for 5 minutes.
Okay,
then.
okay, we'll be in recess for 5 minutes and be back in action in 5. What's that? I'm trying to get it going while we're young here. Okay, we'll call the Children and Family Law Committee to order at the 10:44. And we come out of recess. We have our Associate Representative Markel at, at the desk. And we have your card, Representative Markel, you have the floor.
Okay, thank you, sir. I appreciate the opportunity to speak on this bill. A little bit about me. I sit on the Child and Family Law Committee. I also sit on the Health, Human Services, and Elder Affairs Committee. I've also sat on a couple of subcommittees, long-term managed care, a subcommittee looking at the child, looking at family division. A little bit about my background. I'm a practicing attorney. I was admitted to the New Hampshire Bar in 1998, Massachusetts Bar in 1998, Massachusetts Supreme Judicial Court, 1998, New Hampshire Supreme Court, which is the same thing basically as being admitted, 1998, United States Court of Appeals, First Circuit, 2001, I believe, United States District Court for Massachusetts, United States District Court, New Hampshire. I'm also a practicing attorney in family law. We're having working basically as an independent contractor for Family Legal PC, which is a Concord-based law firm, which has a practice which is heavily concentrated in family law, although we handle criminal cases and some general civil litigation as well. I speak in support of this bill for a couple of reasons. Number one, I think we had a bill last year that was going to deal with endangering the welfare of a child. And it needed some fixing. Some of the adjustments that were needed were whether or not lines were going to be crossed, and in other words, where there might be unjustified prosecution of an individual who was engaging in an activity that might be or might not be questionable. The problem is that it left a little too much discretion to a prosecutor, and it would put people, and arguments were made on the House floor, that it would put people at risk, their parenting, for example, or those with care or custody of the child, at risk for engaging in otherwise lawful activities. And because of that ambiguity, it was felt to be able to adjust the bill to be able to balance the rights of those parents or those who have legal custody of children or incompetence in their care, who could otherwise engage in responsible, protected activity, and at the same time give law enforcement the tools it needs to be able to protect children, which is a compelling state interest. Basically, what this bill does is, I think it's self-explanatory, but what it does is that it is meant to, I want to make sure the language is in here because it should have been. Okay. Basically, the key language which balances and nuances the piece of legislation can be found at line 7 and line 8. Where you engage in a conduct or a pattern, engage in conduct or a pattern of conduct to expose a child or an incompetent, and then the key operating language here is that line 8, substantial and unjustifiable risk of bodily harm, injury, or death. If you take the risk, you're engaging in a Class A misdemeanor. And if it was negligent, it could be treated as a Class A misdemeanor, but if it was knowing, it becomes a Class B felony. And the important part here is the language, the operating language, which is substantial and unjustifiable risk. So in other words, this will filter out otherwise lawful activity. If you take your child skiing, there's always a risk of serious physical harm in skiing. You sign a release, I think, or at least if you buy a lift ticket, you're basically assuming a risk you can get hurt. If you have a child playing football or other serious contact sport, the child is taking a risk, you're acknowledging a risk. However, based on a two-pronged test, this would not be subject to prosecution as it was previously brought up in last year's legislative hearings, floor debates. Because first of all, it would have to be substantial and it would have to be unjustifiable. And those words permeate the our criminal statutes. Skiing, there's an obvious benefit to skiing. High school football, there's a benefit to high school football, but does involve serious risk of harm. So it has to be A, substantial, and B, unjustifiable. What would be substantial and unjustifiable? Exposing a child to drugs. You can probably imagine pretty much anything else. So this would give the police, and it's important language because it balances the rights of parents and those who have lawful custody of children. If there's any questions, I'm happy to take them.
Thank you, Acting Chair, and thank you for taking my question, Representative Markell.
Sure.
So I took the existing 639.3 that went into effect on January 1st of this year.
Right.
And I compared it to the changes that you have put here. And so in the new law that took effect now, in Section 3, it specifically refers to solicitation of a child under 16 in sexual activity or creating a visual representation of child sexual acts.
Right.
You've taken that out and replaced it with negligently engaging in a conduct or pattern of conduct that endangers the health or safety of that child, that causes serious bodily injury or death. And so my question is, how does that impact the manufacturing of child sexual abuse images? Because now we have it, but child sexual abuse images could theoretically just be an unclothed child, not a child who is engaging in activity that causes serious bodily injury or death.
Okay, well, good question. And the answer is twofold as I see it. Number one is engages in conduct or a pattern of conduct so as to expose the child or incompetent to a substantial and unjustifiable risk of bodily injury or death. Now, it might not be prosecutable under that interpretation. However, those actions are independently prosecutable. If you're you can be endangering the welfare of a minor by conduct. That might be it. The second thing is those things are independently prosecutable. If you're manufacturing child porn, you are at very serious risk of lengthy prison sentences, both federally and I'm certain under the state. I think federally, if you're manufacturing, I think you're probably looking at a min-man of 30 years.
I just have one follow-up. My
One
follow-up
follow-up.
is on Section 2. I disagree with that interpretation, but my follow-up is on Section 2. Section 2 of the current law that took effect January 1st is about tattooing or branding children. And I could see how that could be considered serious bodily harm, but I've also, in this state, lost DCYF cases with broken bones, significant reconstructive surgery needed, that was not protracted harm or serious harm because it did not risk death. So I worry, I guess my question is, why take specificity out and leave it up to prosecutorial discretion?
Well, the couple of reasons that I think make sense. One of the things what happens when you're drafting legislation is that you run the risk of painting yourself into a corner. And you run the risk of either being under-inclusive or over-inclusive. And either one of them, those things can create problems. So statutes need to be flexible. And I would think that somebody who either negligently causes the fracture of a child by exposing them to a substantial and unjustifiable risk at home, risk of harm, I consider a broken bone to be that kind of risk. Because somebody in DCYF may not see it that way, that's going to be a question, that's going to be a factual inquiry for a court to decide whether or not, for law enforcement to decide whether or not it's actionable.
Okay, thank you very much for the questions. Representative Scher.
Thank you, Mr. Chair. Are you aware of HB 257?
Can you tell me about that?
Yes, it's a bill that was amended in House Criminal Justice to change the mental state for child endangerment under paragraph 1 to reckless instead of purposeful.
Okay.
That passed House Criminal Justice unanimously. It went to the floor, and in our last full session, early January, it passed the House by a strong vote, and is now in the Senate. Would you be? Do you think it's appropriate to wait on this bill until we see what happens to HB 257 in the Senate?
You could. On the other hand, if you're adding the requisite, if you're adding another, if you're adding another mental state, reckless, you know, it certainly could be added here. You could certainly, if you decided you wanted to keep this for interim study, you could. However, I think this does the job in and of itself.
Follow up.
Follow-up,
Sure.
Representative.
This bill appears to have a negligent mental state that prosecutors can use earlier than they currently can use to prosecute somebody for parenting that they think is negligent.
Okay.
Do you?
Follow-up?
I'm sorry. Last follow-up.
I didn't know
Oh,
that was
that's
an
fine.
answer.
I'm sorry. Well, no, you know, what we're talking about here is basically a criminal negligence standard. And so if you're at a criminal negligence standard, basically it's, you know, you should be aware of a substantial and unjustifiable risk, but you weren't, but you should be. And that's going to be judged in the totality of the circumstances.
Is it fair to say that parents, one or more parents who get a misdemeanor conviction under this statute are going to have a harder time getting a job and a harder time getting housing by virtue of that misdemeanor conviction?
It's certainly possible. I would think, however, there are certain types of criminal convictions that might reflect even more adversely that don't involve this type of conduct. For example, I would think it would be much more difficult to get a job if you were convicted of a crime of dishonesty.
Thank you.
Okay, thank you. Did you? Representative?
Thank you, Chairman. Thank you for taking my question and for being here for your bill. I am curious because we have heard that you have taken out specific pieces of this. And by the way, as a committee, we hear more and more about how kids are not protected in the state. We want to strengthen these protections. So you have taken out specific clauses that have been left in purposefully about the sexual exploitation of children, as well as the branding and damaging of their bodies. So how is your bill strengthening that when we take out protections that we currently have on record?
Okay. Sexual exploitation of children, I think, is also chargeable under other statutes. I think if you take a look, I think you'd see it there. Anything from enticing to computers to, I think it's there. I don't have the whole statute criminal code in front of me right now, but I think I could probably find something that would apply to that. And as to the second part of your question, this is generally pretty broadly based because it covers, once again, we go back to inclusivity, under-inclusive and over-exclusive. So if you wanted to say includes but not limited to, you could certainly amend this if you wanted to add that language if you felt that was important. But I think this covers a very broad spectrum of conduct, which engages with mental state.
Okay, follow-up, Representative?
Thank you for the follow-up. So as a follow-up, if you remember when we talked about this child endangerment, we had law enforcement come in last time. They needed specific things within the child endangerment statute because they were hunting, trying to find appropriate punishments for, what they saw as egregious situations. So do you think it's not great to rely on other statutes based on that knowledge when we're talking about child endangerment, that it would not be in here?
Well, if, I can answer that in two ways. First, if you believe that if the statute needs to be amended, we can certainly amend it and put that language in. The second thing is that the criminal code, as I understand it, is fairly comprehensive. And there are child protections. And I think that endangering, and so what you could do if you wanted to make that amendment, you could certainly add that, which includes but is not limited to, and you could make that adjustment if that would be the thing that you wanted to do. Beyond that, I think this covers a very wide range of activity. Once again, going back to manufacturing, child pornography, for example, is independently chargeable both federally and state. Meeting up with children for the purposes of sexual encounters is also something already there. And remember that this statute is specific to parents and those who have legal custody. So that wouldn't necessarily apply in all circumstances.
Okay, we'll hold that right there. Representative Lowe?
Thank you, Mr. Chair, and thank you for taking my question. You mentioned a bill last year, I believe it was Senate Bill 23.
Okay.
It was overturned on the floor, and the reason being, the waiver of injury claims against Pop Warner or Little League or whatever. And because our statute doesn't seem to have any parameters as for what is or what isn't, more importantly, what isn't,
Right.
child endangerment. Wouldn't it be wise to put something in there to give a judge or DCYF or anybody some parameters that, that football is not, taking your kid skiing is not, if your kid's a good water skier and he wants to ski at 50 miles an hour is not, I have a friend that at 15 years old, his daughter was driving stock cars. Okay, she was a lot more protected than any car out there. But DCYF and a judge could say, hey, that's really dangerous.
Mm-hmm.
Okay, I took my daughter hunting at 7 years old.
Mhm.
Okay, there's some judges that would say that's really dangerous. I had her shooting a gun at 8. Okay, that's really dangerous. I think we need to put some parameters in as to what it isn't.
Well, I think you're asking a very good question, Representative Love. Typically, when I look at statute, once again, I'm going to go back to inclusivity issues. There may be something out there that we haven't thought of. The risk of being too specific is that you end up painting yourself into a corner.
Mhm.
And generally speaking, these things are judged in the totality of the circumstances. So, for example, if you're saying, at the extreme end, with some of the arguments that were made before, taking your child skiing, taking your child hunting. For example, if you're looking at certain types of activity where there are limiting, and remember the key terms here are substantial and unjustifiable. For example, you mentioned taking a child hunting,
Mhm.
shooting a gun.
Yep.
Okay, I was at summer camp when I was a kid. We had riflery. Okay, so not a problem, as long as you're maintaining the appropriate safety protocols on the rifle range. I remember being 9 years old at summer camp. We had single shot 22s, and we had a firing line, and we had all that. So you're not taking a substantial and unjustifiable risk. If you're on those same facts, if there were no range officer present, if children were being unregulated and pointing guns at each other, loaded guns, if children were not supervised, that I think would qualify as endangering a child. But a father-son going into the woods, engaging in traditional outdoor activities, and with all due care being between the father and son, child safety, child is taught how to handle firearms, and so on and so forth. It's going to be judged, sir, in the totality of circumstances. That's how I see it.
Thank you.
Sure.
Thank you very much. Oh, one moment, Representative Raymond?
Thank you. I wanted to follow up on two things. One is that I just want to make sure that everyone's aware that people with a duty of care are not just parents and guardians. It's also babysitters, coaches during coaching time. It could be teachers. It could be daycare providers. But my question is about the word unjustifiable,
Mhm.
because I've been looking, and a lot of our criminal statutes in New Hampshire have definitions of terms. They have purposefully, knowingly, recklessly, negligently. I can't find a definition in our criminal codes for unjustifiable. And so I'm curious how that would play out in prosecution, because my area of expertise is family court law and family law and not criminal law. How would that work? Are there other places that I can't find that I'm missing? And what kind of proof do you have that it's unjustified as
Well,
opposed to reckless or negligent?
okay. Well, substantial and unjustifiable exists in a number of ways. For example, if you are, for example, and the criminal statute would be, for example, criminal negligence, for example, would be shooting a gun in a crowded area where you should be aware that you're taking a substantial and unjustifiable risk. And so that will result in largely, and if somebody is injured as a result, you'll probably end up facing criminal charges. These terms, substantial and unjustifiable risk, appear frequently in criminal law. And they also appear in civil law as well in terms of negligence. So the difference between a knowing mental state and a criminally negligent mental state is basically it's basically a form of awareness. You should have been aware that you were engaging in conduct which created a substantial and unjustifiable risk of harm to others. And
Hold there.
Sure.
For timeline, we have one more question. Is that okay? Representative Scher?
Just to add to Representative Raymond's question, substantial and unjustifiable is used in the criminal code a significant amount, but it's never defined. That's up to the judge or the jury. My question is just channeling Representative Love's concern. It's your opinion that going out shooting with one's child doesn't count as substantial and unjustifiable risk, but a judge or a police officer might think differently, correct?
It's possible, but once again, I respectfully direct back to my question. If you're taking your child or somebody who is entrusted with your care, whose care is entrusted to you, engaging in an activity, let's go back to the shooting. If you have taken due care and used all possible and used foreseeable safeguards, you're probably not taking a substantial and unjustifiable risk. And once again, these cases will be judged in the totality of the circumstances. Can I say that there would never be a prosecution on those facts? Of course not. But what I'm saying here is that I'll go back to the example. I was 9 years old. Riflery was part of our sporting activities at the summer camp I went to. Range officers present, strict supervision, single shot 22 bolt action rifles. Those are the kinds of things. And of course, you need parental consent for this kind of activity. But in other words, back to Representative Love's thing, it's highly unlikely that he would be charged for engaging in a lawful activity where all reasonable measures were taken to protect a child's safety. And once again, it goes back to the definition, substantial and unjustifiable risk. Now, if there was no justification whatsoever for it, it would be unjustifiable. For example, if on those facts, if you knew a child had a predilection for bad behavior or dangerous behavior, or had expressed some kind of feeling that he was going to go out and kill somebody with a gun and something like that happened, yeah, you'd have a problem. Let's go back to, for example, that case in Michigan where parents were found to be liable. I think you may be aware of it, Representative Scher, where the parents were actually found liable because they got their child a pistol, and they pretty well knew what he was going to do with it and gave it to him anyway, and he went into a school and committed a mass shooting. So you're going to get that kind of liability.
Okay, thank you very much. All set? No further questions? Thank you very
Yeah.
much.
Thank you very much.
We will call the end to the hearing on House Bill 1185 and await the chair to call the next bill up, House Bill 1710. Thank you very much.
Thank you, everybody, for your indulgence. I will now open the hearing on House Bill 1710, and I will call the prime sponsor, Representative Markell, to open the bill. And Representative Scher, can you change the hearing number for me? So we will now open this bill, House Bill 1710. Thank you. Today we're good.
I
Okay, at this time, Representative Markell, would you like to give us some opening statements and introduce your bill to the committee?
Yes, thank you, Madam Chair. My name is Jay Markell. I am a sponsor of 1710. This bill is going to be part of the, as proposed, is a child abduction, getting it out. Okay, Child Abduction Prevention Act, which governs actions to prevent children from being abducted and taken out of a jurisdiction where there may or may not be a Hague Convention. It also allows for basically preemptive activity, if you will, to be able to prevent that from happening. Just a second, if I may, go get a piece of information on this. Thank you.
Absolutely.
Thank you for your indulgence, Madam Chair. I appreciate it.
You're very welcome. You may proceed.
Okay, thank you. So that's basically what this bill does. On the information that's provided for me, this is part of an effort. There's a body of, there is a body called the Uniform Law Commission. And what their intention to do, as I understand it, is to be able to introduce model legislation that states that states can adopt on their own and can be customized to the individual needs of the particular jurisdiction. That happens in a number of circumstances. For example, there is actually a Uniform Parentage Act, which has been adopted in a number of states. It provides model statutes that states can conform to their own. The advantage of doing so is that when you sign on to these kinds of programs, is that there's a predictability and uniformity of statute that might otherwise not be there. And that's one of the key benefits of doing it. Doesn't unduly compromise a state's ability to act on its own by customizing what it feels it needs for its own jurisdiction. In the shortest sense in this bill, this will allow people who are subject to a child being taken and be able to take preventative measures for that happening. Speaking from my own practice experience as a family law practitioner, very early in my practice, I had something similar happen that suggests that had this been a law at the time, the results may have been different. I'll recount it briefly. Many years ago, I had a case in Massachusetts where the parents were not married to each other, but living together. And the mother was a Dominican citizen, and Dominican Republic, that is, and the children by birth were Dominicans. One day, he came home and he found his apartment was stripped bare. He had no idea where the children were. The apartment was completely cleaned out. There was absolutely no furniture, nothing. And there were no abuse prevention orders or anything else involved in this particular case. To make a long story short, by getting the State Department involved and by getting a private investigator involved and getting the Miami-Dade Police Department involved, we were able to stop her and getting an emergency order out of the Essex County Probate and Family Court, getting an emergency custody order. We were able to fly him down to Florida, get the order domesticated, have her served with it while I wasn't there, but at the time it was happening, I was on the phone to both the Miami-Dade Police, and I had earlier been on the phone with the State Department. And they apparently stopped her at the airport in a car, and she was probably headed for the Dominican Republic. And my client was able to present the order to her, which he got an emergency domestication in Florida. As I mentioned, he got emergency custody of the children. They were brought back to the Commonwealth of Massachusetts. Had that not happened, chances are good he might not have seen his children again, all three of them. So the court ordered their passports held, so they couldn't do that again. So when I saw this bill, I was thinking of that case particularly. And so this might be something that we'd like to consider. I'll be happy to take any questions.
Representative Nelson.
Thank you, Madam Chair, and thank you for taking my question.
Of course.
Excuse me? Sorry, you were very good on time, by the way, Representative. Have other states adopted this language?
Yes, they have, to varying extents. My understanding is there is a gentleman who will also be testifying on behalf of this bill who may be able to give you more specifics. But the information that I was provided suggests that, and let me double check it here. that currently 21 states have enacted the Uniform Child Abduction Prevention Act. And I'm reading from an email here that I received late last year. Michigan, Pennsylvania, Maryland, Washington, D.C., and legislation is pending in Missouri and West Virginia. And this act can be customized to provide for the individual needs of the state.
Thank you. Representative Scher.
Thank you, Madam Chair. And thank you for your testimony, Representative Markell.
Sure.
The one concern I have is I look at page 2, line 34, and page 4, line 33, and both use the expression credible risk of abduction as the standard that has to be met for a warrant to be issued under this proposal.
Yes.
I don't know what that means, and how would you relate the phrase "credible risk of abduction" to probable cause, to a preponderance of the evidence, to clear and convincing evidence, to proof beyond a reasonable doubt? How does that fit in those more classic standards?
Very good question, sir. Thank you. Once again, this is basically going to be a very subjective determination. And a credible risk is going to be, in my opinion, has to be more than something like, I'm afraid he, she is going to take the children or remove the children. I would want something more than that. I would think that this would be a fact-driven determination. I would want to see not just, I'm afraid, I'd want to see emails or something suggesting airline tickets were purchased in the children's name. I would want to see the dates of departure. I would want to see credit card statements, something along those lines, something that gives me something to hang my hat on.
Follow up? Follow up?
Follow up.
Thank you. Might it be more clear for judges and litigants if the standard were preponderance of the evidence or clear and convincing evidence? Because the credible risk of abduction it's like a new term, and the kinds of things you describe, wouldn't it be easier for a judge making the determination if they were doing it in the context of clear and convincing evidence or preponderance of the evidence?
Clear and convincing might be too high a hurdle, I'm thinking. Preponderance, more likely than not, get the ball over the net. You could say that. However, by analogy, I'm thinking of this in a dissimilar way, and something that's not too far off from this in terms of credible risk. I'll be brief. Petition for certiorari was just denied in the United States Supreme Court in the case of Philip Marquis versus Commonwealth of Massachusetts. One of the issues that was presented in an amicus brief because of unlicensed gun possession was under a Massachusetts permit standard, was to whether or not a permit should be issued for a gun. However, if there was a credible risk of harm or a credible reason for somebody not being denied the permit, okay, then Massachusetts has the discretion to be able to deny the permit. So it's amorphous. However, the United States Supreme Court denied cert. So I'm thinking that is something to be considered. And as my late stepfather pointed out, and it's a well-worn statement, law is a seamless web. And so we find terms that overarch and overlap each other, and we find concepts that go from one aspect of the law to another. And so you can find credible risk, you will find substantial and unjustifiable harm. You will find that these terms will repeat in various venues, in various forms of statute, in various ways.
Thank you. Representative Nelson.
Thank you, Madam Chair, and thank you for taking my question. this kind of is a follow-up, I guess, to Representative Scher's question. In several lines subsequent to 34 and 35, there are many different specific examples
Mhm.
of what would be evidence to prove that there's a credible risk of
Okay.
abduction.
Okay.
So would you feel like that's sufficient to take care of that question about the wording?
Well, yes, and one of our favorite catch-alls is when we're drafting is including but not limited to. So that may be something that we would want to consider. So if we're looking at as some of the things that a court shall consider, any evidence of that the petitioner or respondent has previously abducted or attempted to abduct a child, has threatened to abduct a child. And as it continues here, has recently engaged that he plans on abandoning, a planned abduction, including abandoning employment, selling a primary residence, terminating a lease, and a lot of other things. So what you can add there is includes but not limited to, okay? That way, once again, we talked about the nemesis of statute, which is over-inclusiveness and under-inclusiveness. And so we don't paint ourselves into a corner.
Representative Levesque.
Do you see this negatively affecting cases where one person is born in the U.S. and is sponsoring someone, and they got married, they had kids, and then they're abusing the person from the other country, and they're basically holding that I'm sponsoring you, you can't do anything, and so they're afraid to go to the police, so they do leave the country. They are making attempts to leave the country and make sure that their kids are safe, that they are safe,
Mhm.
so that way they can eventually get sole custody of the kids, because there are cases where they are scared to go to the police. They are scared to go and fight for custody in our legal system because there is that threat of getting deported and not seeing their kids.
Right. Very good observation, and thank you. That obviously is something the court's going to consider, and as it is in virtually all cases, there are going to be three sides to every case. There's going to be one side A, side B, and probably the truth, which might be somewhere in the middle. So you might actually have somebody, if that person were to seek legal counsel and that were the problem, obviously I would probably want to avail myself of a domestic violence petition or abuse restraining order as the facts and circumstances might indicate. That might be something to consider. But I'm also aware of the fact that not everybody is going to be thinking clearly and rationally under intense pressure. So that's going to have to be something that would have to be argued in a court. That's my view.
Thank you. Representative Scher.
I promise, last question.
Don't make promises you can't keep.
It's tough, I know.
I'm sure the next bill you'll have questions.
Last question on this bill.
Okay, good boy.
Following up on what Representative Levesque asked, is there a concern that this could be used by abusers as a weapon to get custody from their significant other spouse or partner, whatever, who is trying to escape the abusive environment?
Always a possibility. And that's a very good observation, sir. Once again, that's going to be a factual inquiry for a court to decide as I look at it, viewed under the totality of the circumstances.
I'm going to keep my promise.
It wouldn't be necessarily another question. It could be a follow-up, sir.
Does a follow-up not count as another question?
Well, kind of, sort of.
I'm gonna
Good
not
boy.
ask another, even a follow-up.
Thank you kindly. Do I see any other questions? Representative Corzine.
Thank you, Madam Chair, and thank you. Um, s- Statutes like this have been adopted in other states. Have there been any constitutional challenges to this type of bill, and how was that ruled?
I'm not aware that there are. However, when I see statutes like this, the challenges that are going to come, as I see them, are going to be probably in the area of parental rights and and it's going to be a real tough call. By way of further answer, we've heard about things like parental alienation. We've heard about things like talking negatively about a child, and we've heard people talk about things like First Amendment and so forth. And those cases tend to fall into the cracks constitutionally because there's a lot of flex when there's a lot of flex in bills like this because remember, you are dealing with a situation where you in all likelihood don't have an intact family or you have other problems. And most of the parental rights that we talk about are usually dealt with intact families. And by way of further answer, intact families get very high protection, but there are ways by which the state does enter the parent-child relationship, and this is one of them.
Thank you. Any further questions for the representative? Thank you, Representative Markell.
Thank you.
Next, I'll call on James Scully. Thank you for coming today, Mr. Scully. You will have 3 minutes as you have asked, and then you can decide whether you'll accept questions or not. You may proceed.
Thank you, Madam Chair. Appreciate it. My name is Attorney James Scully. I have recently been appointed to the Uniform Law Commission. There are 2 commissioners for the state of New Hampshire, myself and Charles Mooney. So as a recent appointee, I apologize because this is my first time, but I will certainly do my best. So thank you, Madam Chair and members of the committee for the opportunity to testify in support of House Bill 1710, which would enact the Uniform Child Abduction Prevention Act, or UCAPA. To begin, the Uniform Law Commission, or the ULC, is a nonprofit organization formed in 1892 to draft nonpartisan, consensus-based model legislation in areas of state law where uniformity among the states is advisable. New Hampshire has a long history of enacting ULC acts, including the Uniform Child Custody Jurisdiction and Enforcement Act, the Uniform Commercial Code, and others. This House bill was drafted through a careful collaborative process involving ULC commissioners, family law experts, child advocates, family court judges, and domestic violence victim advocates. It has already been enacted, as the representative stated, in 20 states, as well as the District of Columbia, and New Hampshire is now considering joining these jurisdictions. The core principle behind this House bill is that preventing child abduction is always in the best interest of the child. While existing laws like the Uniform Child Custody Jurisdiction and Enforcement Act and the Hague Convention provide mechanisms for the return of abducted children, they assume the child can be located, and in the cases of the Hague Convention, that the child is in a country that is a signatory, noting that if there is a country that is not a signatory to the Hague Act, we can't operate under that act. UCAPA fills a critical gap by providing courts and parties with tools to prevent abduction from happening in the first place. This House bill allows parties to seek abduction prevention measures at any time, even before a custody order is in place. This is especially important for parents who fear their child may be wrongfully removed or retained, giving them a chance to seek preventative relief from the court. The Act provides clear, evidence-based guidance on the warning signs and risk factors for potential abduction. These include overt signs, like previous abductions or threats, as well as behaviors such as an abandoning appointment, liquidating assets, or obtaining travel documents. The more risk factors present, the higher probability of abduction. This House bill also addresses international abduction risks, requiring courts to consider whether a child might be taken to a country that is not a party to the Hague Convention or to a country that poses additional risks. If the court finds, as we most recently spoke about Representative Markell, that a credible risk of abduction, it can order a range of tailored prevention measures such as travel restrictions, placing the child's name in the State Department's Child Passport Issuance Alert Program, or requiring the individual to obtain a matching custody order from a foreign country. In summary, this House bill is a carefully crafted, flexible tool that empowers courts to prevent child abduction before it occurs, protecting the well-being and safety of New Hampshire's children. I respectfully urge the committee to support this bill. Sorry, I was 3 seconds over.
Great job. I have a question for you, sir, and then I'll ask the committee if anybody else has them. How many countries are not signatories to the Hague?
The first question is a difficult one. I am actually not sure how many countries are not party to the Hague Act.
Do you know of any particular countries that are not?
I don't, but I'm happy to do some quick research and get back to you.
I would appreciate that if you could send that to the entire committee.
Absolutely.
I would greatly appreciate that.
Absolutely.
Thank you. Representative Pearson. Representative Gregg, I apologize.
Thank you, Madam Chairwoman. Is there a risk about the weaponization of this, that somebody who is trying to escape an abuser, that this could be used as a weapon against that victim?
Absolutely. So I'll give you my personal stance based upon my reading of this statute. Personally, I believe that what this statute enables, or what this potential statute enables, is for the prohibition of travel with the risk of abduction. So could it be weaponized? In theory, potentially, but it couldn't be weaponized like a custodial hearing or something to that effect, because really what this does is it prevents the ability for the children to potentially travel. So revocation of passports and things of the like. So it's not a mere custodial discussion. The courts will still have that ability during a custodial hearing, but this is rather to limit their ability to pose the risk of an abduction.
Follow up?
Thank you, Madam Chairman. So, but for somebody who is, let's say, not a national here, that they're a national in another country, trying to get back to maybe their family or their support system, it certainly in that case could be weaponized by, let's say, an American citizen here who is an abuser who's trying to keep them from getting to their support system, correct?
So I believe that the way that this is drafted currently is, could it be weaponized potentially temporarily? But the way that this act is done is for a custodial hearing to take place. So rather than those children be removed, whether lawfully or unlawfully, to a foreign territory, this enables the court to weigh in prior to that child or children being removed. Whether it's lawful or unlawful, this will pause that for a custodial hearing to take place.
Thank you, Representative Raymond.
Thank you. Representative Gregg's question just made a little question pop up in my mind about, when someone seeks this order, everyone keeps talking about, you and Representative Markell were talking about, holding the passports in order to prevent the children from traveling out of the country. Who does that? Like, do you have to turn them into the court, to the other parent? Like, what happens to them?
My understanding is the State Department has authority over passports, so the court would order that the State Department withhold their passports on a temporary basis.
So it's not like a physical necessary restricting the passports. It's like a flag that goes up.
Correct. The
It's
State
like
Department
a do not fly list or something.
Absolutely. The State Department does have a database that they maintain for passports. And so if anybody is labeled as a risk, that flags, and so they wouldn't be able to travel.
Fascinating. Thank you.
Absolutely.
I have one more question. In your opinion, isn't it up to the court? And are they not capable of understanding the difference between escaping harm and abducting a child?
again, as Representative Markell said, everything is a subjective basis, but I would agree completely that the court has the wherewithal and the experience to identify the difference. I think what's helpful within this proposed legislation is those identifying risk factors that are based upon years and years of experience with child abductions and the people that weighed in at the Uniform Law Commission, to which I was not present because this was done in 2006.
And you were still in elementary school, right?
2000, yes, ma'am.
Thank you so much.
Absolutely. Anything else?
Seeing no other oh, I do see one more question, Representative Nelson.
Thank you, Madam Chair. This is a quick one. Do you have a copy of your testimony that we could maybe make photocopies for the rest of the committee for our record, or could you email that to the committee?
I can do both. I have a copy right here that I'm absolutely willing to provide. I do have some notes on the top, or I can email a clean copy to you all.
I think emailing is fine. Right. Thank you very much.
I will include that with my Hague research.
Thank you kindly.
My pleasure. Thank you all very much.
The next card I have is from Mary Kruger, who has also asked for 3 minutes. And I might mention that gentleman, James Scully, is in support of the bill, and Mary Kruger is cautiously in support of the bill or study. Thank you. You're welcome to begin.
Thank you, Madam Chair and members of the committee. My name is Mary Kruger. I'm with New Hampshire Legal Assistance. We're a statewide nonprofit law firm representing low-income clients and vulnerable adults. I am here, I guess, cautiously support. I wasn't exactly sure what to put, frankly, on that card. I will say that there are some red flags for me about this bill, but I do understand that the kind of the underlying policy could be quite helpful for domestic violence survivors. And that's one of the practices we have at New Hampshire Legal Assistance, is representing domestic violence survivors in family court. And so in our experience, we know that survivors are often threatened that if you leave, I will take your children. And those threats can be very real. And this kind of law could be extremely powerful to assist those survivors. However, as has been raised, it could be used as a weapon against survivors who want to relocate for safety in particular, and that's a concern. It's a fairly complex law, and it's intertwined with many other laws, including the Uniform Child Custody Jurisdiction Enforcement Act, which is a fairly complicated act about which state has jurisdiction, the Parental Kidnapping Act, which is a federal law, the relocation law in New Hampshire. And I think that if we were to adopt something like this, we would need to really maybe refer courts to the comments to the uniform law that really describe and explain kind of how to implement this, because I do think that courts will have a challenging time figuring out how to apply this law, and that could result in harm to families and children. So I think that studying this would be really important for this committee to do, to see, we've already heard there may be some words that aren't exactly right in what's written here. And that would be sort of my recommendation, would be to spend more time working on this and studying this, looking at why only less than half of states have adopted this when it's been recommended since 2006. There's lots of questions, so I would just really caution the committee moving forward as written. Thank you.
Representative Scher.
I amend my earlier comment that I had no more questions on this bill to say, I have no more questions on this bill from Representative Markell, but I do have one. I do have one question for this.
You are forgiven and
Thank you.
given latitude.
I appreciate that. Would you be able to propose language that might decrease the possibility of weaponization use of this bill, understanding it's a complicated bill?
Maybe I really need myself more time to sort of think about this and understand it. It's something, fairly new to me as well.
Representative Pearson.
Thank you, Madam Chair, and thank you, Councilor, for taking my question. Since 20-some states have this, I would assume there are 20 legal assistance organizations. And it might be instructive to see what their scruples were, how they were overcome, and that would be instructive for us, perhaps, if an amendment were crafted. Would you believe?
Yeah, I
That was a
agree. I do think that we could find out more about how in the states that have adopted this, it's operated and what are the lessons that we can learn from that. I agree.
Thank you. Thank you.
I have one question for you. In your practice, are you aware of any of the numbers of men and women who have been put in a position where they feel like they have to fight or fly? In other words, fight and flight. And if if you do know of any of those cases, have they gone to court and court rulings been handed down?
So, if you're asking about relocation, so where someone is trying to relocate with children for safety, we have what I would consider a fairly strict relocation law. It is difficult for victims to be able to demonstrate and meet the standards that we have on relocation from this state to another state, much less another country.
And in your opinion, would this bill make it a little easier for people who are in horrific, abusive relationships to protect themselves and their children?
This is a preventative bill, so it's a little different than, I don't think it would assist someone in their relocation necessarily. It would prevent an abuser from following through on a threat that may be very real, that they'll take the children somewhere else and follow through on the threat when the victim decides that they do want to leave. So I see these as, I don't see it as necessarily helpful for a victim who wants to relocate. I see it as potentially problematic, as it would be used as a way to prevent that victim from relocating because someone may allege that they are trying to abduct the children. They may allege that first, and that could be the first thing that gets in front of a court is, this parent is who's trying to relocate for safety. An abuser could say, I am going to file this prevention petition in order to stop them from taking the children, even though the reason may be for safety. And sometimes in our relocation law does allow for that emergency relocation, where the safety is at risk. So someone could do that, and this could be filed as a way to prevent that person from relocating for safety. And so that's the concern that I have about this, is that it might be misused that way to further control the victim.
Thank you. Any further questions? Seeing none, thank you very much for your
Thank you.
time. I have one final pink card. It's for the Honorable Betty Gay from Salem.
Betty Gay from Salem. There's so many red flags in this bill that I will do my best to read my bullet points, but the more nervous I get, the worse my writing is. So, this is punishment prior to the commission of a crime. There's no hearing, there's no notice of hearing, there's no due process. This bill sounds like the action it authorizes when assuming the risk of abduction is for the state to take possession of the child. Reviewing custody hearings is not the primary recommended action. Two serious current international cases of abduction charges have put two protective parents into prison because the first court awarded their child to the abusive parent. Typically, I personally know one who lost her home, lost her job because she had no other choice but to leave New Hampshire, go to Connecticut where they were more believing, and they gave her their address to use her ID, the protective department, whatever that is called. So they believed her, but the judge here did not. She couldn't, in good conscience, leave her child to be given to the abuser. He had already demonstrated many times the abuse, but her judge refused to allow her to present evidence or testimony, which is another point of many of our bills, to put constitutional rights back into family court. Typically, tragically, mothers are at a very high percentage of not being believed when they claim domestic abuse. It's considered a ploy that they use. Very high up judges have said to me in testimony in the LOB, how do you know she can be believed? And I was polite and said the same way that you evaluate any testimony. What I should have said was, how do you know he can be believed? This bad practice of awarding custody to a parent of DV happens frequently. Paid court attorneys don't necessarily feel sympathetic because when you award custody to the abuser, not that they think it is abuser, but it's the accused person. The other person they know will continue to use their services to come back to court again and again.
Your time is up.
Okay.
If you'll take questions, maybe the rest of what you had to say could be answered.
Okay.
Any questions for the Honorable Representative Georges?
Thank you, Madam Chair. Thank you for saying that because I didn't really have a question to ask him, but because I know, like you said, there is some abuser. He knows what to do too, like to get a child. I have a situation that the mother have a custody of the child, but the guy asked for divorce, but he wanted just to get a custody of the child. But the judge gave it the mother. But the father, because for the 2 days what he can get the child, when the child go back home, always have a problem. Disrespect, abuse, start to say even the things what is not good.
Representative, is there a question in there?
Yes, my question is just because last time they saw with a scissors, why that scissors? The father asked, and all those things is that, but he didn't want the court what the divorce was. He went now to Supreme Court, just the father.
And your
Because
question is?
he wanted custody of the child. That's what I want to know. Like somebody like this, he wanted just the custody of the child. And
Ms. Gay, can you answer to that?
Could you rephrase the question?
my question is, there is some abuse because you want to just a custody of the child to keep just looking for a problem to like for the woman because
Are you asking if the abuser is asking,
yeah
is
she want,
making it up?
yeah, making up with all of the story just because you want to just to have a child.
Well, that is my great fear. That is my great fear that this legitimizes acts requesting punishment prior to even the commission of a crime, and it is a crime to abduct a child already. I'm afraid this bill will be a powerful weapon in the hands of abusive parents.
Thank you. Representative Gregg.
Thank you, Madam Chairwoman, and thank you, Honorable Betty Gay, for being here and taking my question. You said that you had a number of concerns. Would you mind emailing us the list of concerns once you've had time to go home and kind of list them? Would that be possible,
I'll do the
please?
best I can. There are so many points here. That's another thing. When I was in Health and Human Services, we had a really great committee, and we suddenly got a whole lot of bills from the Senate that had, I'll say 47, maybe only 20 different bills combined. And one of the things that concerns me is this bill has so many parts to it that unless you study every single one, you could pass something that's really bad. But we were saved from one part in a bill by a woman who flew from Illinois to point out what was one of the sections that was going to really harm her attempt to rescue a child who had been awarded to, they wouldn't even consider her, and she was a real good family responsible person. So I'm thinking that if all these bad things that people think would lead to abduction, they should already be visible. That ought to be something that can be brought up in a custody hearing. This punishment prior to the commission of a crime sounds totally against our constitutional rights.
Thank you. Representative Nelson. I apologize.
Sorry.
Any other questions
I
from
did, but I don't.
the committee? Representative Pearson.
Thank you, Madam Chair, and thank you, Representative Emeritus. I get the word out before I'm.
That's
If there's so
classier.
many red flags in the bill, why do you think 20 states adopted it?
Lots of states are not very sympathetic to domestic abuse. It is an international problem, especially in English-speaking countries like Australia, Great Britain, the U.S., Canada. I'm thinking of one of the cases that's current that the woman escaped. She was her child was granted to her abusive ex. So she picked the child up and left. She had enough money. She could go. She was a model who'd made a lot of money. And so she went to 4 different countries in a row because every time when she realized they had found her, she went to another one. She ended up in Austin, which you would have think, that would have been a friendlier place. No, they said, we're going to put you in prison. She never had a chance to plead her case. She never had a chance to show the victim, to show the domestic abuse that she'd been through, that she observed with her child. It was just, you're a fugitive, you've broken the law, and we're going to put you in jail. And then they finally said, well, if you sign this agreement that you will never see your child till after they turn 18, we won't put you in prison. We need reform terribly all over the world. Women, even though in our state, men get abused too, and the courts recognize that, but we still have both parents, both sexes of parents, getting really bad decisions and really poor ways of appealing.
Thank you.
Thank you.
Thank you.
Seeing no further questions, thank you very much. And if you could email us your list of bullet points, that would be greatly appreciated.
Thank you.
Thank you. Seeing no other pink cards, I will close the hearing on 1710. At this time, I will let the committee know that we'll go to lunch and we'll be back by a little before 1 when we will hear the final bill of the day. Thank you.
Okay, good afternoon, members of Children and Family Law. We will call our 1 o'clock meeting to order and recognize the representative who was there a moment ago in launch position. There you are. You may approach the bench and advocate for House Bill 1460. FN.
Thank you, Mr. Acting Chairman. I almost had failure to launch, but I finally launched. Good afternoon, and thank you for allowing me to do this. I received a communication this morning from Representative Litchfield, who is the sponsor of this bill. Unfortunately, she has a family issue and cannot be here today, so I am going to introduce the bill. I do not have a lot of information about the bill, so I will refer you to the people behind me who will speak on the bill. And Representative Litchfield has asked that if anybody has any information or needs any information on this, they can contact her. And she also asked if she could attend the executive session so that if anybody had questions, could she answer them then? And I gave her permission to do such, which we usually don't allow in executive session. But if any of you have questions for the representative, I will allow it during executive session because this is not the norm. So this is House Bill 1460 FN, prohibiting the sale of location and other sensitive data regarding children. This bill prohibits the sale of any location or sensitive data. And I'm not sure, because the bill is so short, what the precipitous is and what information she has on this bill. And I apologize, I didn't receive the communication until I was on my way here. So I don't have much information to give you.
Thank you, Madam Chairman. Just for the record, is there any questions that could be offered? Representative.
Thank you, Mr. Chairman. So I understand, Representative, that you don't really have many answers. My only thought is that we currently have statutes on the book that protects privacy and data. So I'm just wondering, in your opinion, wouldn't those statutes also cover the sale of? I mean, to me, it seems almost to be a moot point. Though I understand you don't have much information, but just trying to get a sense of your thoughts on that.
Well, if memory serves me correctly, I believe that there are laws that have come about, and some of those laws have not been implemented yet. And this all comes about, and I don't know if this is where she's going with this, but I do know that in some cases when minor children are on things like TikTok or things of that sort, or if they're on Xbox or any of those games, their information can be pulled in from those services, and those companies do sell that information. In some cases, I have heard from my grandchildren, because I don't play any of those games. My granddaughter tried to teach me how to do Roblox, and I was like, can't get this figured out. My thumbs don't move like that. Anyway, some kids say that they're over 18, but they're not. And there's no way for those companies to track whether you're over 18 or not. You can put in any kind of a fictitious birth date and name, and they won't know who you are. But that's how these children fall victim to these companies. And that's one of the reasons I personally believe that we have such a horrifying situation with human trafficking of children. That's the best answer I can give you.
Thank you very much. Representative.
Thank you, Mr. Chair. So, understanding that this is special circumstances because we don't have the prime sponsor here, and I'm a little confused about what this is. In the case where you said that, TikTok, if the kids lie about their age, this still would not pertain to that. But I did want to say we do have one of the co-sponsors here. So is there anywhere in procedure where maybe Representative Markle could answer any questions if you're not as familiar?
If Representative Markell would like to come out here and testify, that's up to the chairman.
Okay, that's really my question. Because I think that any questions that I do have are going to kind of get into the weeds. And I feel like because this is the hearing, we should be able to get into the weeds as much as possible.
Mm-hmm.
Well, we will do that. We'll recognize the Honorable Betty Gay first and then have Representative Markell. And I do need a pink card, Your Honor. Well, today. Yes, it's under appeal.
And ask the chair not to get carried away in addressing Representative Mark.
Love it.
Listen, gentlemen, there's only room in this room for one queen. Okay?
Oh, boy.
Is there going to be a vote on that or?
This is a monarchy.
Anything further you'd like to add, Madam Chair?
No, sir, I have nothing further to add to this conversation.
Okay, with no further questions from the members, thank you very much for introducing the bill.
Thank you for your indulgence. I appreciate it.
Okay. Oh, thank you. What was that?
I'm getting the timer out.
Okay, I'd like to recognize the Honorable Betty Gay to offer her testimony on House Bill 1460.
I was Betty Gay, Salem. I was concerned what's the change in wording, so I was looking to see RSA 507H6. They just added a little line, not process personal data in violation of the laws of the state and federal laws that prohibit unlawful discrimination against consumers. That didn't fit very well in my head, but the one before it, D, not process sensitive data concerning a consumer without obtaining the consumer's consent, or in the case of the processing of sensitive data concerning a known child, without processing such data in accordance with COPPA. It almost sounds like this paragraph would go better with D, because can a child give permission to let somebody take their data?
Mm-hmm.
So this is saying they can't do it. So it sounds like a open and shut, easy, this is a good addition, but you might find some other legalese that needs to be addressed. To me, it's a good idea. The purpose is definitely good.
Questions, Representative Raymond?
Thank you, and thank you for taking my question. Would you believe that the COPPA, which is the Children's Privacy Act, which is a federal act, gives parents the right to consent to the sale of their children's data? And it gives the right to children over the age of 13 the right to consent when they're on things like TikTok or other social media sites, which is consistent with our RSA 507H, which is our Data Privacy Act as well. So right now, under both federal and state law, it is the parent who chooses. And this, I would assume this bill would make it just illegal entirely, so parents could no longer make that choice. But I would have to ask the prime sponsor.
Well, it also points out that by just saying children, since the other laws that you're citing cite the age of the child, I think this one would need to cite the age of the child too.
Well, one of the question I just wanted to broach, maybe with Raymond and yourself, Madam Gay, where it says in the methodology was stating covered entities. Is this, I don't have a copy of 507, I would say 507, but when it's dealing with covered entities, is that something that this bill would also, or possibly also by interpretive action, expand what the covered entities are to protect the release of minor, young people's information?
Your time's up, Mr. Chairman.
Oh.
Kidding.
Done. You're in order. Okay.
Well, I think we're bringing up real important questions, so when everybody rereads 507H6 and answers these specific questions, because I don't know the answer to that, but it certainly, I think most of us want to keep it tight so that we do stop the selling of children's data, location of data, and how do you access the kids. Definitely, we're concerned about that. So good luck at writing it carefully. And specifying age. That's just one point.
Understood. Anything further for Honorable Betty Gay? All right, thank you very much.
Thank you.
Then we'll recognize Representative Martel.
Yes. Thank you, sir. Yeah, I would speak in support of this bill. After looking at the present statute as it is, I guess the only thing I would say is when you're saying children under the age of what? But outside of that, I would think it would be fine.
If I may, what Raymond referred to, she said the age of 13.
Age of 13? Yeah.
Is
That
that
would be, if that's the right age, then yeah, I would be fine. I don't see anything wrong with this bill at all.
okay? Questions? You'll take Representative.
Thank you, Mr. Chairman, and thank you for humoring us and going out there to answer some questions. So
Sure.
I think that you probably heard Representative Raymond talk about this, and I am curious, does this prohibit it completely, or would it still allow, because the way I read it, it prohibits it completely, which takes it out of the parents' hands to either opt in or opt out on that. How do you read that?
Well, I think what you would probably do is, if you're saying without parental consent, 13-year-olds, children 13-year-olds and under really don't have the capacity to consent to too much. And I think correct me if I'm wrong, but Facebook doesn't allow children to have accounts if they're under the age of 13. I think it's also, correct me if I'm wrong, expanding on this a little bit. Did Australia just restrict social media to children under the age of 16 and restricted them? So I wouldn't have any problem with that. 13-year-olds, yeah, that's really just too young. And if you're defining it as 13, that's where I see it.
Follow up?
And then one other question, this doesn't appropriate any funding for this. Do you think this could really be upheld, or that they could prosecute this or anything without any funding at all on this?
Well, I don't know that you necessarily, after having looked at the statute itself, I don't know that you necessarily need that. If you wanted to add something like any entity or controller that violates any provisions of the statute shall be subject to liability or damages as prescribed by law, if you wanted to add a penalty to it. Yeah.
Thank you. So we've been talking about, social media and other applications in regards to data privacy, but our New Hampshire Data Privacy Act 507 H is just data. So it also applies to things like the academic applications that charter schools are using, or homeschooling programs, There's the Power Scholars program, just as an example. It refers to the Children's Scholarship Fund. It refers to any entity that is collecting any kind of identifiable information about children, including their names and addresses and et cetera. So I guess my question is, would this would this prevent parents from opting in to some of those homeschooling programs, sharing of some information? Like, for example, if a homeschooling program wanted to coordinate with another program for a summer camp or for something else, would this prevent parents from opting in to some of that data sharing that is allowed under our current statute that went into effect last year?
Yeah, okay. I'm sorry, but Representative and Chairwoman DeSimone indicates it deals with selling. Do I have that right? Deals with the sale of the information. So I don't think it has to, I don't think you have to worry about that.
Thank you for clarifying.
Representative.
Thank you, Mr. Chairman, and thank you for taking my question.
Sure.
I can't read the mind of the prime sponsor, but I'm actually wondering if this may have come about by the recent discovery of Power School, which is a communication tool used in a lot of public schools, including a lot of New Hampshire public schools, and including my own in Derry, where the schools share information to the parents, and they have been involved in class action lawsuits because they've been selling student data to third parties. Maybe that's where the impetus for this came from.
It's possible, sure.
Representative Scher.
Just to address what Representative Nelson brought up, the extent to which any government entity is selling data to a private entity that is personal or private information, it violates Part 1, Article 2 of the New Hampshire Constitution, which prohibits the government from either collecting or giving out personal or private information. I know this because I wrote that provision in the Constitution. So, if the circumstance, I know this doesn't directly address this, but if the circumstance is a government entity of any sort is selling data to a private third party, that becomes problematic because it's used by the school district. The school district, in effect, is sharing data with a private entity. So I know it may be a problem. Excuse me? Yep. But it might get in the way of that sharing relationship.
Anything further for Representative Markell? You good?
Oh, it was,
Okay.
oh, okay. Thank you.
Thank you, sir.
Of course, thank you.
Okay, my sense here is, if there's no other further testimony to be offered, is not having the benefit of the prime sponsor to say what brought this to the table.
Yes.
And therefore, as suggested by Madam Chair, is this would be part when we have executive session next week, that that opportunity to provide that information would then be offered for the for Representative Litchfield, with the agreement of the board to put it on, make sure we put it on the agenda. Representative Scher.
I would just caution us. It can be dangerous, particularly if there's substantial questions about a bill, to try and exect a bill the same day that testimony is heard. So I just want to leave open the possibility that once we hear from Representative Litchfield, we may want to move the time we exec it to a later time if there's sufficient concerns.
Right, no, that's a good point, and that can take place at any time for a rescheduling. I mean, that's been my own personal history over the last 22 years.
Mr. Chairman, would it not be possible to have a continuance on this and continue the hearing at a later date?
Yes, that's with the agreement of the board. That could be adjusting the schedule. They hear that first, and then, with the chair's agreement. We'd hear that first and then doing our executive sessions in total after. Oh, well, we have a timing requirement, so it's an early bill. Madam Chair, then you can. With no further input, I will close the hearing on House Bill 1460 FN.
Great job again.
Thank you very much, Your Honor. Thank you.
He brings a note of realty to the subject. I know.
Thank you very much. The bills that we've heard so far are early bills, and I believe, and Caleb is here in the room, the date for reporting out is February 5th. Is that correct? The 12th? Okay, so we are really not going to have time to continue anything, and that's why we're execing next week. As much as I would agree that if we had more time, I'd be happy to do that. And that was the only reason that I told Representative Litchfield that if anybody had any questions, she could appear at the executive session, but we would hear people's testimony who came today because she didn't even contact me until I was on my way here. The poor thing, my heart goes out to her and her family. Representative Gregg.
Thank you, Madam Chairwoman. Chairwoman, since you have a conversation with her, is there any way that you could ask her to please send us an email stating, why the bill came about and give us some more information? I just really am, I know it's an early bill, but I'm very uncomfortable executing legislation without even understanding where it came from and stuff. If she could just send us an email, that would be great.
Absolutely. That's a great idea, and I'll be happy to do that right now. I'm not going to email her. I'm going to text her. Do we have any further business to be brought before the committee today? Well, I thank you all again. We've had a wonderful day. I will definitely text Representative Litchfield right now with your request, Representative Gregg. I think it's a great request. I thank everybody who came here today and testified. I thank Ms. Kristen for being at our beck and call. And have a safe trip home, and we'll see you next week.